In statutory construction, legislative intent is the pole star. Legislative intent is the pole star. E.g. Johnston v. City Council of City of Greenwood Village, Colorado, 1972. Johnston v. City Council of the City of... Johnston v. Greenwood Village, Colorado. So the gravamen of felony menacing is that the specific intent is that the perpetrator has to want to cause fear and only cause fear. They want to cause fear in another person, and that's with a deadly weapon. That's the basic of felony menacing. Now, I will admit, I will give to you that felony menacing has a lot of the similar elements to warning shots. I fired 3 warning shots, so felony menacing is similar. On evidence, shot through the heart. CRE strongly favors the admission of evidence. The trial court has broad discretion in determining the admissibility of evidence, and the trial court's decision will be only reviewed for abuse of discretion. Medina decision, Colo 2003. So which is it? They strongly favor the admission of evidence or not? But I was Article 2, Section 13ing. Article 2, Section 13 says I have a right to bear arms in defense of home, person, and property. When it comes to evidence, polygraphs are not admissible. In Colorado courts, polygraphs are not admissible in Colorado courts. Fingerprints are admissible. Polygraphs are not via 1981 Anderson decision. The 1981 Supreme Court Anderson decision. Fingerprints, however, are admissible. According to the 1971 Solis Supreme Court decision and 1972 Supreme Court decision, Hervey, Solis and Hervey. QEEG is inadmissible, so polygraphs in QEEG, which is some kind of technology, inadmissible via Trances v. Hilburn. 1997 Colorado Appeals decision, VF video fluoroscopy. VF video fluoroscopy is admissible. Trances v. Hilburn, Colo App 1997 decision. Circumstantial evidence is not only admissible, but enough circumstantial evidence is also enough to convict a person. Circumstantial evidence isn't to be treated secondary to direct evidence, but it's considered under the same criteria. 1971 Diebold decision, 1971 Durbin decision, 1975 Salas decision, 1971 Elliott Evans decision. Circumstantial evidence is good evidence. They say that it's not the same as direct evidence, but that it's considered under the same criteria. But it makes a point that it's not direct evidence. Hypnotic trances. If you got a testimony from a hypnotic trance, those are inadmissible. Diaz Colo Appeals 1983. People in the interest of MSH Colo 1983. Videotape is good evidence. The 2017 Colorado Court of Appeals Valdez decision says that the recording showed the crime as it was happening. You can't argue with videotape. Videotape is the truth. If it's not clearly doctored, edited, deep faked, the videotape is exactly what happened. The videotape is the truth. Videotape is admissible where the probative value outweighs the unfair prejudice. Videotape is admissible where the probative value outweighs the unfair prejudice. McCone, Caddy v. Rego, County, Colorado, 1990. So videotape is admissible. Videotape is good evidence. So is fingerprints and circumstantial evidence. And so is video fluoroscopy, according to Trances v. Hilburn, Colorado Appeals 1997 decision. But QEEG is inadmissible. Hypnotic trances are inadmissible, and polygraphs are not admissible. So let's just get that right. Polygraphs not admissible. Fingerprints are admissible. QEEG is not admissible. VF video fluoroscopy is admissible. Circumstantial is admissible. Hypnotic trance not admissible. Videotape is admissible. A person's gang affiliation is relevant and material evidence according to Moya, Clark, Mendoza, Fernandez, 1994, 2015, 93, and 1994, some DNA is admissible, inconclusive, or no conclusion DNA is not relevant direct evidence. P.V. Marks, 2015, Colorado Court of Appeals. Tape recordings, photographs are good evidence, or they should be good evidence. The admissibility of all this is within the sound discretion of the trial court. 1975 Quintana decision. Some exhibits can be used. Use of exhibits from earlier trials not prejudicial. The court reporter's identification marks was harmless error, not prejudicial. 1973 Gallegos. Doubtful exhibits must be kept away from the jury. Doubtful exhibits must be kept away from the jury. That's 1971 Zamora. 1971 Zamora. So that's just some laws of evidence. We need factual, not legal, nor conclusory information from witnesses. P.V. Fueston, Colorado Supreme Court, 1988. Rule 902. Rule 902. Extrinsic evidence of authenticity as a condition precedent to admissibility is not required with respect to the following. Rule 902 is self-authentication. Domestic public documents under seal. A document bearing a seal purporting to be that of the United States or of any state, district, commonwealth, territory, insular possession thereof, or the Panama Canal Zone, or the trust territory of the Pacific Islands, or of a political subdivision, department, officer, or agency thereof, and a signature purporting to be an attestation or execution. 2. Domestic public documents not under seal. A document purporting to bear the signature in his official capacity of an officer or employee of any entity included in paragraph 1 hereof having no seal. If a public officer having a seal and having official duties in the district or political subdivision of the officer or employee certifies under seal that the signer has the official capacity and that the signature is genuine. 3. Foreign public documents. A document purporting to be executed or attested in his official capacity by a person authorized by the laws of a foreign country to make the execution or attestation and accompanied by a final certification as to the genuineness of signature and official position, A, of the executing or attesting person, or B, of any foreign official whose certificate of genuineness of signature and official position relates to the execution or attestation or is in a chain of certificates of genuineness of signature and official position relating to the execution or attestation. A final certification may be made by a Secretary of the United States, diplomatic, consular official, or foreign country assigned or accredited to the U.S. if a reasonable opportunity has been given to all parties to investigate the authenticity and accuracy of official documents. The court may, for good cause shown, order that they be treated as presumptively authentic without final certification or permit them to be evidenced by an attested summary with or without final certification. Certified copies of public records. A copy of an official record or a report or entry therein, or of a document authorized by law to be recorded or filed and actually recorded or filed in a public office, including data compilations in any form certified as correct by the custodian, compilations by the custodian or other person authorized to make the certification. By certificate complying with paragraph 1, 2, or 3 of this rule, or complying with any federal or Colorado rules of procedure, or with any act of the U.S. Congress or any statute of the state of Colorado. 5. Official publications, books, pamphlets, or other publications purporting to be issued by a public authority. 6. Newspapers and periodicals. So books, pamphlets, other publications purporting to be issued by a public authority. Newspapers, periodicals, printed materials purporting to be newspapers or periodicals. 7. Trade inscriptions and the like, inscriptions, signs, tags, or labels purporting to have been affixed in the course of business and indicating ownership, control, or origin. 8. Acknowledged documents. Documents acknowledged by a certificate of acknowledgement executed in the manner provided by law by a notary public or other officer authorized by law to take acknowledgments. 9. Commercial paper and related documents. Commercial paper, signatures thereon, and documents relating thereto to the extent provided by general commercial law. 10. Presumptions under legislative act. Any signature, document, or other matter declared by act of the Congress of the United States or by any statute of the state of Colorado to be presumptively or prima facie, genuine or authentic. 11. Certified domestic records of regularly conducted activity. The original or a duplicate of a domestic record of regularly conducted activity that would be admissible under Rule 803.6 if accompanied by an affidavit of its custodian or other qualified person in a manner complying with any Colorado statute or rule prescribed by the Colorado Supreme Court, certifying that the record A was made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. B was kept in the course of the regularly conducted activity, and C was made by the regularly conducted activity as a regular practice. A party intending to offer a record into evidence under this paragraph must provide written notice of that intention to all adverse parties and must make the record and affidavit available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. 12. Certified foreign records of regularly conducted activity. In a civil case, the original or a duplicate of a foreign record of regularly conducted activity that would be admissible under Rule 803.6 if accompanied by a written declaration by its custodian or other qualified person certifying that the record A was made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. B was kept in the course of the regularly conducted activity, and C was made by the regularly conducted activity as a regular practice. The declaration must be signed in a manner that, if falsely made, would subject the maker to criminal penalty. Under the laws of the country where the declaration is signed, a party intended to offer a record into evidence under this paragraph must provide written notice of that intention to all adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. Rule 903, subscribing witnesses' testimony unnecessary. The testimony of a subscribing witness is not necessary to authenticate a writing unless required by the laws of the jurisdiction whose laws govern the validity of the writing. Contents of writings, recordings, and photographs. In the beginning, the incoming organizer must establish his identity, or putting it another way, get his license to operate. He must have a reason for being there. A reason acceptable to the people. Any stranger is suspect. If the organizer begins with an affirmation of his love for the people, well, he promptly turns everybody off. If, on the other hand, he begins with a denunciation of exploiting employers and slum landlords, police shakedowns, gouging merchants, he is inside their experience and they accept him. Page 98, Rules for Radicals by Saul Alinsky. You are your own worst enemy. You waste precious time dreaming of the future instead of engaging in the present. Since nothing seems urgent to you, you're only half involved in what you do. The only way to change is through action and outside pressure. Put yourself in situations where you have too much at stake to waste time or resources. If you cannot afford to lose, you won't cut your ties to the past. Enter unknown territory where you must depend on your wits and energy to see you through. Place yourself on death ground where your back is up against the wall and you got to fight like hell and get out alive. Page 41 to 33, Strategies of War by Robert Greene. Chapter 4, create a sense of urgency and desperation, i.e. the death ground strategy. The death ground strategy.